excited to be here today. I am especially excited to have Anna sitting with me in real life. For those of you who don't know, Anna's normally based out of San Diego, but she is in Chicago for today's webinar, so we are delighted to have Anna here. We have a real exciting webinar planned, and it's great to see so many people on already. You know, with immigration, policy is very important because the underlying law can remain the same, but the policy can change. So updates really do happen, you know, from time to time that can be pretty important for your case. So it's important that you're keeping yourself informed. You know, LinkedIn is a great way to get some updates from us and other immigration attorneys. Webinars like the one we're doing now, Anna, and then First Fridays, which is a updates on the first Friday of the month from one of the attorneys in our firm. Alrighty, so there's a kind of some overview of some of the helpful resources.
Today, what we're going to be getting into, we'll give, like Fiona said, we'll try to recap sometimes, so we'll just give a very, very quick background on ourselves, McEntee Law, and then we're going to dive into probably the meat of why you all are here. What is an O1? You want to get one. What are the 3 buckets you need to fill? That's the McEntee Law kind of personal approach that we take to these cases. So we'll chat through bucket 1, talking about O1A cases versus O1B, defining your field of expertise, and then showing how you're extraordinary in your field. And then we'll chat about bucket 2, petitioner, bucket 3, showing future work in the field of expertise. So O1s, immigration is a very broad area of law. It's hard for one attorney to be an expert in even all the different areas within immigration, and we see O1s as a niche even within employment-based immigration cases. So even some immigration attorneys aren't necessarily experts within O1s, and we've had a lot of clients come to us after they've been turned away from a number of other immigration attorneys saying, you know, oh, you're not, you may not fit this extraordinary requirement needed for O1s. But Fiona and I this is what we're known for. And so, you know, today we'll dive in and give you some background on these types of cases.
Yeah. So as I mentioned, the managing attorney here, been working as an immigration lawyer for over 16 years and do a lot of O1s and speak and write on O1s. I've also written a couple of books, but one it touches on O1s for startup founders and other different options for them. But I think, I feel like I don't want to speak for you, but we speak about this together often, that we really do love working on O1s. It's a way for us to be really creative, use the law, the policy, and kind of figure out how to present our clients' cases in the most favourable light for the government. So sometimes they're, oftentimes challenging, but really interesting, and we love the end result as well, hopefully, when that leads to the client coming to the US on their O1. Okay, so here is Anna's little bio here.
Yeah, I'm a senior attorney here at McEntee Law. I manage the O1 practice group. And as Fiona said, I'm based in San Diego, so California attorney, attended UC Hastings, now called UC Law SF, and been practicing immigration law for over 8 years now.
Great. Okay, so here's a quote from one of our clients just talking about her O1 case that we helped her with. It's great to see our clients, come to us looking for, depending whatever visa type, and then ultimately them here in the US and getting to really not to be cheesy, but to live out their American dream and just the opportunities that are available here. I think especially if you're in the influencing content creation, a lot of times people's audience, is in the US, or a large portion of, and they can see the traction that they're getting here, and they want to be here to be able to be closer to that audience.
Some of our, not just content creators, but some of our amazing clients, we do have content creators on this, the Luxury Home Show, we've got Holly Brooks on here too, as well as some bands and some sports teams. So a lot of different opportunities for O1 cases.
Yeah, and Emily there,
Yep.
Orange, she's a fitness influencer as well, along with Holly. And we are so, I think, blessed to be officed in a very creative incubator space here in Chicago. So we work with a lot of musicians, artists, different people in the industry, and it's great that this is where we're broadcasting live from. Although our initial
The Wi-Fi might need some work. But.
Yeah. Apart from that, it's great. No, but this is where we're based, and it's just we're surrounded by creativity, which is exciting for us and our team. There's a cross segment of some of the team. Not everybody there is. Not all our team is pictured. Okay.
I think it's important to, before we chat about, the specific immigration cases, talk about the moment we are in with immigration, and we find ourselves in a pro-immigrant administration right now, and so they're not only backing up their words, they're not just saying words, they're backing it up with action, and we're seeing that in policy guidance and updates, and we're able to use those to help strengthen our cases. I think the next slide actually is an example of some updates we saw come through last year, specifically on O-1B visas. And so, they're making immigration more accessible, not just to STEM, the traditional STEM fields and AI, but here, O-1Bs, which are, for folks in the arts too.
Yeah, and just one thing that because it happened earlier on today where I was consulting with somebody, if you are hiring a lawyer, law firm, somebody to work on your case, you should be seeing some lawyering in your case, right? You should be seeing them use the policy and the law and, whatever pieces of government, words that we have in support of your case. I've seen cases where it's like an exhibit list of just this is the criteria, this is the piece of evidence, and it's like
we've got all this great clarifying guidance here, and so it's really putting meat on the bones of pretty dated immigration laws, and so you want a lawyer that's going to use them to your advantage and use them to strengthen your case.
Yeah, I think it's just very persuasive evidence to use in support of a client's case when we have it. Why would we not be using this stuff, right? I was very passionate earlier on about this, you hired a lawyer, you need to see some lawyering in your case, and that means showing how your evidence fits within the law, the policy, things like that. So that's what we do, and that's what you should expect as well when you hire somebody to represent you and to work on one of these cases for you. Okay, so this is a question that we get asked a lot, and it's kind of how long is a piece of string, right? How hard is it to get an O1? And to be the typical lawyer, we would just say, well, it depends, right? So obviously every case is different and needs to be treated as such. It is possible to file 2 identical O1 cases and have them get different results. One of the things we had seen here, actually, we filed 2 identical cases for musicians. They were a duo, and so the evidence was almost identical. And we got one, O1 was approved straight away. The other was issued a request for evidence and ultimately approved. But it just goes to show you the treatment, is not going to be equal. It's actually quite a subjective thing. So you do need to really put your best foot forward.
And we got a question that's kind of related here and to what we just spoke about on the administration. So the question is, if there's a change in leadership following the election, do you see this having any impact on O1s? And well, we've seen a Trump administration before, and it was not great for immigration. So yes, we can definitely expect to see some impact to all types of immigration cases, including O1s. But we still do have these great policy guidances to, refer to and continue to strengthen out cases.
Yeah, just a couple of thoughts come to mind. I guess briefly, people don't really know how damaging the Trump administration was.
It won't be overnight.
And previously with the business immigration stuff, like a lot of that stuff never really made it into the media because there was obviously horrific other stuff that was going on, like the family separation and like the ending of DACA and the Muslim ban and so. But that administration was very damaging to business immigration as well. But another thought is that O1s, if they can be approved, if they get approved, it can be up to a 3-year approval. So if someone's thinking about an O1, not to scare anybody, but this is the reality, right? We live and we practice in an area of law that is subject to flux very much based on policy. So why not seize the moment, in the moment, with the administration that we have right now that has good policy, which we're hoping, to be honest, will continue, that will continue with great policy, but, I don't know. But I think that it is an important consideration, and that's a great question.
Great question.
Okay, so look, this is something I always touch on. I think I grew up in Ireland, and I think that culturally, it's kind of frowned upon to consider yourself extraordinary, right? We're it's not something that we're quite comfortable with, I think, and that's not just unique to Ireland. I think it's
a lot of European clients that almost get uncomfortable sometimes when they read some of the expert letters that we prepare because the language is so flattering, exactly, and it may not be common in that culture, but humility is not your friend. You want to brag about your achievements and be proud of them and show them off.
Yeah, I think step into all your extraordinariness for the O1 because this is what we have to demonstrate, and I just think if you're feeling or thinking, oh, I just don't think I'm that extraordinary, let me tell you that that's a sentiment that's shared. So it's pretty common for people to feel that way. Now, having said that, the O1's just not going to work for everybody. So, it's not just a mindset thing, but if you have some of these things that we're going to talk about, don't downplay your achievements, and we just want to note this because it's something that comes up a lot. Here is a testimonial from a client that I wanted to share here, but it's somebody who originally was here on a different visa, on a J1, and came, and basically when I started consulting with her, I thought the O would be great. And she was originally like, oh, I don't know. And as we started to work through it, I felt even better about the O1, and she did too. And so we got her O1 approved, and she's been able to be in the US working in her field of documentary film producing. So she's a good example to show how her initial feeling, what I think was based on cultural kind of, just norms there. And she was absolutely extraordinary enough for an O1. So do you want to do this one, Anna?
Yeah, so the O1 is a pretty nice option. Most people think about the H-1B cap as the big employment-based visa option, but O1 is nice because there's no cap. You can file any time of year. It is reserved for those with extraordinary ability, and I see some questions about, what kind of achievements do you need for this, and we'll be getting into specifics in that bucket, but when we talk about extraordinary ability, it doesn't mean you need 20 years of experience, especially for content creation. This is a pretty new industry.
Yeah.
And it can take off pretty quickly. It does take time to build a following, but then once it does, you can see pretty rapid growth.
Yeah.
And it varies. And so defining your field is going to be key. There's a lot of evidence involved. And then that kind of brings us to what we called earlier, the McEntee law approach, which is filling the 3 different buckets, and kind of touched on these earlier. So I think we can just go ahead and dive into the meat of, while you guys are here, we're going to chat about the first bucket, showing that you're extraordinary in your field. And one of the first things that we consider is this an O-1A or an O-1B? O-1A is for, science, education, business, athletics. O-1B is more for the arts, as well as motion picture and TV. But it's not always immediately clear. So, think of a CEO who maybe it's a creative company or a company managing influencers, and that CEO is actually doing pretty creative things in their role. So would it be O-1A for business and highlighting his business abilities, or could that be framed as an O-1B in the arts and maybe focusing more on the creative aspects of the role? So that's just something that we would need to kind of dig and parse through on a consult and look at what evidence might be available. And
yeah, I think it's not, this is something that's not always immediately clear, and I think sometimes it takes, you know, what I like to do after I consult with a client is sometimes just like take some time to let that kind of, you know, percolate down and just like think about how we're going to be setting this scene for their story, right, for their O1 case. We'll think about their day-to-day job duties. Do they lean more creative, or are they more on the business side of things? I know we're here for content creators, influencers. I would say more often than not, this is in the O1B realm. But it's not to say that we can't consider, like, what if somebody's like they're creating business content on their platforms? Does that make them an O&A because it's business content, or are they in the arts because it's the art of reaching people and storytelling? I think we lean more towards that being an O1B, but it's just a consideration because I think this is such an important part of the process, because there's different standards for the O&A and O&B, there's different evidentiary criteria that you need to show. There's some other benefits that the O1B would give you that maybe the O&A wouldn't. So it's an important consideration and one to just think about because it's not always immediately clear.
And so one of the questions was, does public relation come under any of these categories? And again, it depends, right?
I think it's not, don't think about it in like big industry, right? Because if you do that, then you would think, okay, this is a good example. Sports. Athletics is O1A, right? So the field of athletics is generally like if you have extraordinary ability in athletics, you're going in the O1A. But what if you do marketing for a sports team, right? What if you're creating the content for a professional sports team? And this is an actual client that we do a lot of professional sports visas and work with a lot of professional sports teams. So if your job is creative and you're creating content, regardless of the industry that you're in, then you can lean, I think, more towards the O1B. So start to think about your day-to-day job duties. And this is what I had a consult last week with somebody who was just so lovely. And he came in thinking it was an O1A, didn't think about the O1B. And I started to bring up the possibility of the O1B. And it may be still that it's the O1A, but just to think about it. So I said to him, like, walk me through a typical day. You know, walk me through a typical client and the work that you would do for them as well. And when you start to learn about the types of things that they do, if those job duties are leaning more towards creative, well then I think you're leaning more towards the O1B. That's a great question. Keep these questions coming. They're great. Okay, so this is my little phrase.
I know, you saved this slide for you. She loves
my phrase. I love like the fairy tale. I love kind of just using analogies for different things. But okay, so the first thing is we are thinking, are you O&A or O1B? The next thing is, what is your field of expertise? Right, we mentioned the big buckets of like business or the arts or science, but we need to bring that down further. So I call this the Goldilocks approach. Okay, if people are familiar with, I don't know, the Goldilocks stories, I feel like it's like maybe a universal story, but you don't want it to be too broad. You don't want it to be too narrow. You're trying to get your field of expertise somewhere in the middle. So, for example, maybe you don't want to say you're a YouTuber, because then are you being compared to Mr. Beast, for example, right? If that's who is in the YouTube realm, right? But then you don't necessarily want to be, I was trying to think of a funny
just
example.
Something so niche, like I don't know, just Harry Potter content about like this scene
Like
and
Lego figures
and like in this one book and
Yeah.
So you can't. The quote here is ranking at the top of a field of one is meaningless. So again, it can't be so narrow that you're the only one doing this type of work.
Yeah. Just right, and that comes from a case. Where it actually wasn't a field of one, but the judge was they were basically saying that like if it's a very small field, being at the top of it is just not significant. So you need to find that like happy medium, and this is kind of an art form in and of itself. So it's our like Goldilocks approach to this. Someone's asking, is the PowerPoint available? We normally don't make the PowerPoint the actual deck because it's something that we've worked on for a long time, but we do have the video available, and that will be shared with you. But you're welcome to take like screenshots, of course, if you want, but we just don't give out the deck. Okay,
just make sure we look okay in the screenshot.
Yeah, and like eyes closed and blinking. Of course, this is about like content creation, Anna. We have to look our best.
We have to look good.
Okay, so once we've figured out O&A or O-1B, we've done the Goldilocks thing. Now we're getting into the meat of the case, and somebody asked about this, and Anna's going to chat about this.
We're going to put all the evidence together now, and here's a visual representation with like a little pen
for
and
scale.
One of our cases of what an O-1B kind of looked like for a fashion designer. But in figuring out what kind of evidence we're going to be using, we look to the USCIS's list of O-1B criteria. There's 6 on the list here, and you only need to show that you hit 3 of them. And so the other thing with O-1s is that we need to be able to demonstrate past and future will be kind of aligned in the evidence that we use. And so we can kind of chat through these one by one. And so the first is a lead, starring, or critical role for a distinguished company. Well, Fiona, what if I'm a content creator and I don't have like a 9-to-5 employer? I'm doing brand deals. One day I might be working with, this fashion company. The next day I'm doing a post for a totally different company.
Yeah. So here, I feel like sometimes I'm like a broken record when I do presentations on these, including presentations to other immigration lawyers, because I'm always like, policy manual. What does the USCIS policy manual say about each one of these things, right? So this criteria, this list comes from the immigration law, but it's pretty sparse. Like it's almost, we've kind of condensed it down slightly, but it is very brief in the law. But the policy manual is what puts the meat on the bones of the law, and this administration, as we mentioned earlier, has completely updated the policy manual and kind of gone through each one of these and given us things that are, just sometimes there's actually specific examples of what would meet this. But, you do not have to be an employee of an organization in order to have a lead, starring, or critical role with that company. So if you are doing content creation for, let's say, L'Oreal or some kind of, leading brand, by virtue of them hiring you to do some brand partnerships, well, then that could likely qualify as having a lead role for a distinguished company. They're choosing to pick you to, represent their brand online, which is, I think, something that's like, pretty significant and goes to show your standing and your expertise. Yeah, your reputation in the field. Like a brand like that can like pick anybody. And we actually had a great call earlier today with somebody, and what I was saying to him is like, all these boxes that we can check are pulling from evidence that is really kind of bolstering other experts in the field's view of you being an expert in the field. For example, like, a makeup line can pick anybody they want to do content creation for them, right? Anyone. And they pay well, they, have access to just all these content creators. And if they have made a determination that you are a great fit and alignment with their brand, well, why shouldn't we be able to kind of rely on like the expertise of somebody there that's picking you to represent their brand? And so kind of thinking about that, and I just would encourage you to approach an O1 or an immigration case with the same creativity that you approach your business.
That's good advice.
Yeah, like think outside the box, right? While you may read some of these and think in like, oh, I need to be an employee, I haven't worked, like I don't have a paycheck, that's not a salary. You know, well, there's other creative ways to show some of these.
And one of the questions directly on point was, what is the definition of a distinguished company?
Okay, so I would say, well, we can pull from the actual dictionary definition of distinguished, which we do, and we put that in there, the Merriam-Webster dictionary. But you can also show distinguished nature of a company by media mentions, by, let's imagine they did something with the Oscars, or they are featured in press themselves, or they have, their household names, these are
and
the
their
types of things.
websites often have media kits.
Yeah.
And just we can even pull from their own websites directly to kind of bolster that argument and help show that it is distinguished. So that's how we usually approach that.
Yeah, and I'm glad you brought that up though, because
it's not just the L'Oreals and the big names.
No,
So.
definitely not. And it's also not just the role. To check this box, it's not sufficient that your role has been lead, starring, or critical, for example, in number 1. You do also need to show that that happened with a company that is distinguished. Sometimes people look at these and they think you just need to show one thing, but actually pretty much all of these are written in the plural, so that's one thing to note. And written in the plural. So let's say number 1, we're looking at lead, starring, critical role for distinguished companies. So it's written in the plural. We have to talk about your role. We need to talk about distinguished companies and
past and future.
Exactly. It's has and will have. So to check one box, you need to hit on multiple things, lots of different things. But for us, this is obviously our day-to-day work, and we know these kind of cases inside out. And we also know how you can, I'm going to ask you this, can I use one piece of evidence to check off more than one box?
Yeah, we actually often do. So that kind of leads us right into the second one. So the second point is lead or starring role in distinguished productions or events. And so if we're using that beauty influencer with the, brand deals with L'Oreal, we'll list those as showing, they have a critical role at a distinguished company. And then we'll also reuse that same evidence and refer back to it and treat those posts as distinguished productions, because they are.
Yeah, so it's possible to use one to double dip, right? And you could kind of think about that in the sense of, what are your brand partnerships? What are the things you've done? Sometimes people have done actual, physical in-person events, which is great too. And also I would just say to note that, depending on where you're at in your career, if you're looking at the O and you think, okay, maybe I'm not quite
there yet.
Which again, maybe you're thinking that because culturally, or whatever, but maybe that's the reality as well. What you can do is you can kind of hone in on some of these, this list of criteria and see which ones you might be able to work up to. Somebody asked me a great question, and it was during a consult, and she was asking whether or not it would make sense for her to take unpaid or lower paid brand partnerships if the brand was very reputable. And I just thought that was a great question. What would you say if you were asking her about that? And I just haven't shared this question with Anna before. So she's I
think, why not? It's a great opportunity to build up your portfolio, so to speak.
That's what I thought. It's you can...
You may be charging a certain amount, but if you're being approached for not your usual rate...
Yeah.
Just take it as a way to build up your file.
That's what I thought, because it's going to be good evidence, likely for, especially if it's a very well-known brand. I think it would be a career, decision, of course, that but with through the lens of the O1, it might make sense because it might get you more high-profile brand partnerships as well. And you don't necessarily need to show this. So salary or remuneration is number 6, but they don't always have to be connected to 1 and 2, and so it doesn't necessarily have to be, you don't have to have gotten a huge dollar amount or euro amount or whatever
from that specific distinguished production that we're referencing.
Yeah, exactly. So we're getting some great questions that are coming in here. I'm loving all these.
One was about follower count, which is one that we get a lot. Is there like a minimum follower number? And the answer is no. There's not a minimum. So don't think that you need to have 1 million followers before you even can consider this. So I think, again, it kind of, a lot of our answers are going to be, it depends.
On what else you have.
Yeah, so it's going to depend on these other, other boxes within this bucket that we're checking off. And so we'll kind of continue down.
Yeah.
Press is one that I definitely want to talk about because sometimes folks have like maybe just 1 or 2 articles about them, and it's again, it depends. It may not be enough to check off this box as its own criteria, but we love using that to help, again, refer back and help show that, like their role was critical to this organization. Look, it was written about here in this article. And the other thing to be mindful of with press is, let's take it back to that, beauty influencer with her great work with L'Oreal. If there's an article about that work with L'Oreal, amazing. If she also ran a marathon on the side and was featured, hey, she finished 3rd in this marathon, can we use that press for her beauty content creation case? Probably not. So it does have to be relevant and hit on your field of expertise.
Yeah. I think that's a good one because we had somebody who came to us who, I think they were interviewed by the Associated Press, and that was picked up by all these publications, but she was interviewed about working remotely in COVID. And like, unless your expertise is like somebody who is working, who has like expertise in advising people about remote work, and there are people who do that, that wasn't her, but it was kind of like an ancillary, like random piece of press that wasn't related to her field, because actually the press wants, the way the regulation's written, it wants you to be about you and your work, and so it needs to kind of be in there. But I think it is important to talk about press because a lot of people are under, and they're under a misunderstanding that you have to have press, right? And we have worked with some of the really, really big content creators, and they do not have press because they get their traction and all that stuff on social media, and they do not get traditional
press.
Yeah. So it's not a prerequisite. If you have it, we can see if we can incorporate it into your case. But it's just not something that you have to have. So don't feel like you need to go out there and try to get like people to, write about you, because it's not a requirement. It's something that, we can use, but not mandatory.
Yeah. The next one is one of our favorites to use for O-1B cases. That's expert recognition in the form of letters or expert testimonials that our team drafts, and obviously you and the expert will review and edit as needed. But it's really nice in O-1B cases that this is a standalone category that we can check off. It's not the case for O-1A. So kind of, if you remember, think back to that slide where we were talking about first we're going to decide if this is O-1A or O-1B. This is one of the differences that Fiona was kind of referring to. We can use expert letters for O-1A, but they would kind of be to help, bolster our arguments for some of the other criterion. Here, it's its own standalone category, and I use it in, I think, every one of my O-1B content creator cases. It's a very nice way to provide important context to the reviewing officer about an emerging industry like this. Content creation is a new and emerging industry, and so it's great to have these letters to
and Anna, how many experts do I need, and do they need is it okay if they're outside the US or where do they need to be based?
They can be based anywhere. We can use letters from international experts, and we often do. Again, no magic number, but we usually have folks think about 5 to 10 experts, and we won't use all of them. We'll kind of review what each person might be able to speak to and strategize what would be best for your case. But we do like to see at least 1 or 2 from a US based expert. And the reason is for O1 cases, oftentimes, especially in the arts where there's motion, television,
Yeah.
and film, you need to go through the appropriate advisory group. And so really there's no advisory group for content creators.
Yeah.
And so we can use that expert from the US as kind of a substitute for that.
Yeah, like musicians go through the American Federation of Musicians. There's all sorts of unions and different groups. But if there is no group that governs your industry or what you're going to be doing in the US, we can use the US-based experts. Okay, I'm conscious of time, but we're going to quickly, and we have still quite a lot to discuss. I love these questions that are coming in. The next one is major commercial critically acclaimed successes. I use this more, I think, with musicians or with maybe people in motion picture and TV, and less with content creators. It's not to say that we couldn't use it, but I find that really for our content creators, influencers, we're more looking at box number 1, 2, 4, maybe 6 if you are getting some significant remuneration, which, I mean, some of our clients really do.
And again, don't think of this as the traditional, it's not necessarily an annual salary, right? The ways that we've used this can be a little more creative.
Yeah, like if you think about if you're getting paid X amount for a post, how long does that post take you to do, and what is your hourly rate, right? So you can kind of think about it in that sense. And I think sometimes people are making pretty significant money per video. So thinking about the time it takes you to put that together. So yeah, don't think about it in like, I'm not getting a paycheck, I'm not an employee. It's salary or a significant remuneration, so we can think outside the box for that.
So think of those partnership deals that you have.
Yeah, exactly. And again, like let's say you're the person that didn't get highly compensated because you thought, it would be better for your career to get, more of the, maybe a lesser value amount. You can still use that as like, let's say number 1, number 2, and then maybe you're using the expert recognition. So maybe you're not quite there yet with the high salary, but you only need 3 out of these 6 boxes.
One more quick question about salary from, how do you meet the high salary requirement? Is it in comparison to others?
Yes, because something's only high if it's higher than what other people are getting. Now, in the US, if you're based here, we have some great wage data that we can pull from. But the policy manual and just the guidance says we don't need to compare you to people in the US if you're not here. So it's based on where you are located. So we would kind of look to see what the average salary for your industry, for your position, and then try and make that kind of comparison there. Because yes, it's something is only high if it's higher than others. So, but that is something that can potentially be used for you. So this is the list here. I think a mistake that we see. Oh, here, I'll talk about here. I'll go on to this slide really quickly so we can share our approach. I'll let Anna talk a little bit about this.
Yeah, so how we do this is first we get on a strategy meeting, and this is like sometimes an hour-long call because we really want to talk to you about what's your goal, or what's your ideal scenario coming in here, and try to find the best fit, and then again looking over all of your evidence, discussing what might work best for your case, or again, like for example, that press category, maybe we're not going to use it here, maybe it would be best to help strengthen another category. And then we'll kind of do an internal meeting. Fiona, myself, some of our other team members will kind of huddle up, come up with the case strategy. And then hot tip from Fiona, the O1 expert, and she's kind of taught me to do the same, is going back to this list, some individuals, some immigration attorneys even, feel like they need to hit every single bucket, every single one of those criteria. And we rarely, if ever, do. We pick the 3 strongest, maybe 4, and submit really good, really strong evidence for those rather than mediocre evidence or weak evidence and just trying to hit all of them. So it can be, I think, a fatal mistake to cases.
Yeah, I think so, because, I just earlier was looking at a request for evidence that somebody got from another firm, and I just think they, not to diss any, people approach these things in different ways. Yeah. However, in my experience, why force a fourth, fifth, sixth that is weak, because it makes your whole case look weaker. And if you can stand by the criteria that you're picking for you, to me it just does not make sense to try to reach for something that just doesn't apply. Like, if you had a piece of press that wasn't maybe national, would you just try to check the press box? I don't think I would do that. I would use that in another way.
Yeah.
If you had like one event, would you, I think the reality is you do have more if you look at them, right? So I just think it's be selective is again our approach, and that's what I think, what we think kind of works best.
I think we touched on, we definitely touched on the press, and then what kind of experts. So yeah, I did talk about the experts, but I don't think I mentioned, who would be a good fit. So that for this, I would suggest thinking about other content creators, especially within, so again, our beauty influencer friend we keep referring back to, if she's got other influencers or content creators that she knows, others within the wellness and beauty industry that can speak to, that have their own achievements, and we can establish them as experts in their own right and who can speak to her accomplishments. But we also, maybe she has a great relationship, and because of that partnership with L'Oreal, we use letters from companies as well. Because as Fiona mentioned earlier, this is a big brand, they can work with anyone. And so the fact that they trusted you enough to work with you speaks very highly to what you're doing.
Yeah, and your reputation.
Yeah.
Okay, so let's imagine we have, we're checking 3 of the boxes, we're confident in the ones that we've picked. The next thing that we need to think about is, how is this case going to be structured? To be totally honest, we could spend an hour just talking about this part of it right here. But the takeaway here is that there's multiple ways to structure the case. It is really important that you sit down with your attorney and you hash this out from the get-go, because it is really, the whole basis for the filing, and will, kind of frame just the structure, right? So we talk to clients about what's potentially on the table, and what are your goals, what do you want to do when you're in the US, like what are the types of things that you would imagine yourself doing, and then we talk them through the possible options. So if you are coming in to work as an employee and you have a job offer, that's a straightforward employer-employee petition. That's not normally what happens in these cases.
If it was L'Oreal, she's only working with L'Oreal. She cannot take any other...
As their marketing manager, for example, you're coming in to run their brand. Okay, well then they're your petitioner, you're the employee, and that's how the case is set up. But I think more often than not, if you can see the slide here, people are not aware or just don't really understand how this can work, but you can actually set up your own company, and that can be the petitioner for your case. You're not allowed self-petition in your own person, but you can set up an entity and that can be your petitioner. And that is a way that I think gives people a ton of flexibility. I will say that some immigration attorneys are not familiar with how to structure cases in this manner, and it's something that we have been shouting from the rooftops. Yeah, because it's not anything underhand, like it is permitted.
No, it's permitted in the law.
Yeah, and it's mentioned in the Foreign Affairs Manual. So again, like knowing these policy things, these guidance inside out. There's also other ways to structure it, like if you have a company outside the US, somebody here can be the petitioner for you. But I just don't want to dwell too much more on this, because I know we have a bunch of questions. We also got some questions ahead of time that we're hopefully going to touch on, and we're getting some questions here today. So Anna, so that's bucket number 2, is like the petitioner who's going to file a case. Bucket number 3 is
showing that you're going to continue to work in your field. So we need to have specifics, and so a lot of times it's really helpful to have those letters. So maybe L'Oreal is going to write a letter saying, yes, she's done some great work for us, and speak on that. And also we have these upcoming projects that we're really looking forward to hiring this, content creator on, and using her while she's in the US in O-1 status. So we need to be able to show that there's specific, and continued plans, and it has to be, again, in the field of expertise. So it can't be all of a sudden she's switching to maybe a different type of content. All of a sudden she's posting about cars or motorcycles or something like that. So it has to continued employment in the same field of expertise.
Yeah, and that's why defining your field of expertise is key. Like, they're all interconnected, right? Because if you remember the evidence, the boxes that you need to check, we do need to show past and future, and so the future work can tie in here to like showing that you're going to continue to work in your field. It can also be somehow related to your petitioner structure, and also showing bucket number 1 that you're meeting, the extraordinary ability criteria. So they're all interconnected, and this is why it's really important that you sit down with your lawyer and kind of say, this is what I plan to do. These are the types of opportunities that are coming my way. You can request an O1 for up to 3 years. But it can't be speculative employment. So that means like you can't just be like, oh, I want to come in and like see what happens and like I'll stay for up to 3 years. No, to get the O1 approved, we need to show evidence of what you're going to be doing. I think if you're in if you're, let's say, a YouTuber where you're monetizing your platform, you are creating your own content, and like you kind of can be fully independent in that. Well, then your continued work in the field looks a little bit different to somebody whose platform involves a lot of collaboration. So it's important, I think, that whoever you're working with kind of understands how you operate your day-to-day and what your work in the US can look like. But I mean, for me, the best part of the job is telling clients that their case gets approved, and then like continuing to see their social media when they come
really
to the
cool
US.
to
It's amazing, like to see
the
the
moving to the US posts.
Yeah, and like visa approved, and like then to just see what they can do when they get to the US. It's definitely, I think, the best part of the job. And obviously we can't guarantee that we can get any case approved, but we do have a lot of experience. Okay, somebody asked about how long does an O1 visa last?
And this is kind of related. So
that's a good question.
So as Fiona said, you can request it for up to 3 years, but again, we need to show that there's going to be reasonable amount of projects and future employment. And somebody asked if the visa is approved for the full 3 years. Does the 3 years start from the date of the approval or the date of moving? And so it kind of depends on what date we list. We usually try to like plan out for a visa stamping appointment, and so if a case was being filed today, April 17th, maybe we might not date it until June or late May or something. So it would be 3 years from that date. And
from the requested date.
It's
neither the approval date nor the date that you moved to the US. It's whatever the date that's requested in the petition. We will request up to 3 years, and like as Anna said, we can plan it. You can request up to 6 months ahead. You can file it like early with a future date, and so we can kind of work with you to.
Or if I just don't even want to. I have to wrap up my affairs here. I might not move until December. Then we can list December.
Mm-hmm. And then you could save on the expedited premium processing as well. Okay, so what I think we should do, we'll briefly mention, there's a green card version of the O1 standard
just some
fire.
Key takeaways: it's a more elevated standard than the O1. We like to use the O1 to test the waters before. We don't really recommend going straight to the green card. Mm-hmm. And no letters as a standalone category for this one.
Yeah, but instead of there being the 6...
there's 10.
Oh yeah, there's 10. Here we go. Instead of there being 6 for the O-1B or 8 for the O-1A, it's mushed together, and there's 10. But you can fully self-petition for the green card. Now, let's go through some of these questions.
Can I study and work on an O-1?
So yeah, your work is going to be based on how it was listed in the petition, and you can study on the O1 as well, but just know that your O1 work is dictated by how it was framed, and any changes would potentially require an amendment.
Yeah, so it depends how we put it in the petition. You can't all of a sudden get a side job as a barista if that's not what we put.
Unless you're an expert, that's your job.
Area of expertise.
Yeah.
What if you take a career break less than a year but commanded a high salary remuneration in your last job before the break? Can it be still used to fulfill, the high salary? So
yeah, I think it could. I mean, I think it's I would say that it all forms part of the narrative of your case. I would try to figure out what you were doing if you were truly on a complete break in that time, but I would also say, is that the strongest box for you, or is that one of the ones that maybe we wouldn't push for because there's just ones that are stronger? So I would just say, like, let's holistically look at the case and see which ones make most sense. But I think if you've commanded a high salary for a significant period of time, and then you take people take breaks for a variety of reasons. Now the O1 does, there's kind of an idea of like striking while the iron is hot and not having like, kind of like stale evidence. So, there's some finessing maybe and strategic planning there.
Do you want to talk at all about paid press placements, aka fake press?
I mean, okay, like press is one of the things that is helpful when it is, I think, organic, and when it is generated based on the work that you're doing. Press releases aren't considered press. Random blogs that you're mentioned in is just not sufficient for press. So I don't think that people should be going out and trying to get press,
we never recommend like paying for it or seeking it out. And again, as she said, with that section, we dedicate a whole paragraph and tons of supporting evidence to the legitimacy of where it was published. And so that's part of it too.
Yeah. These are such great questions.
I know, they're amazing.
Okay, so
can the agent be a U.S. citizen, family member?
I would just say, why are we looking at the agent? Is that the best one for you? I don't think there's any prohibition on who can or cannot be the agent necessarily, but I just would say, why is that the best way to set it up, or would you be better off just setting up your own petitioner and have that be setting up your own entity and have that be the petitioner for you?
I love this question because it made me think of one of our clients. As a content creator, is it wise to share the journey of going through the O1 process in the moment, or can that hinder the application itself? We had a client that did document like the whole thing, and she waited until everything was approved and kind of shared the news with all her followers, had an amazing YouTube video that, like, I think we both cried when we watched.
Like that emoji.
Yeah. So I would say let's just wait until we're in the clear on the other side of this with an approval.
I would say, because look, your social media is completely fair game, especially if you're putting yourself out there as a content creator. Where do you think they're going to go to look, right? And if you're online saying like, oh, I don't know if this is a good fit for me, but like, I'm nervous about it, I just, we'll have to wait and see. Well, I feel like that is like going to influence the adjudicator who's reviewing your case. And so I would say I totally agree with Anna. Hold off until hopefully you get the green light and get your visa stamp even issued. So
and that would be an epic it's just like with all the the build up over the months. So.
Like document it, but maybe not like post it until everything is our opinion.
A few questions about the green card, because I know we like just breezed over that to get to the Q&A. So why don't you want people to go straight to the EB1, and is there a minimum time of living in the US before you can apply?
No, there's no minimum time. You can actually apply from abroad. I don't think we said we don't want people to go straight to the EB1A. It is an individual analysis that needs to be done with people. There are some people who do want to go straight to the EB1A. I just think you need to tread carefully, because by filing a green card in EB1A, the start of that petition, you're indicating a permanency, right? And the O1, while it lives somewhat in a hybrid land between temporary and maybe not, it's just there is some legal advice that you need to assess the risk about whether it makes sense for you to go ahead and demonstrate that intent by filing the green card straight away, or does it make more sense for you to springboard, stepstone from the O1 into the EB1A green card.
And when I said using the O1 to test the waters, it is a great way, because if we saw some pushback, or if they requested some more evidence, maybe on press or whatever, one of the categories, then we know, okay, maybe that one wasn't, we can find ways to strengthen it even more, because the green card is an even more elevated standard than the O1.
Yeah, exactly. And like this, obviously, as we mentioned from the start, general info, this is a big decision for anybody, massive decision, which really deserves time to be devoted, both from our end and from your end. And it deserves an investment in time and a consult to just see, because it is very individualized, and there's risks and there's pros and cons. So, just I would say give it the time it deserves. There's some other, somebody said,
Spouse.
get to document
I
it
know,
and make
so
us
you can,
cry.
I know, love that.
Love it.
Spouses, for the lovebirds out there who might be coming with a spouse, so you can bring a spouse with you. They will not be work authorized. And so the question was actually, is it possible for the spouse to get approved for a visa as well? Yes, they can. Just showing your O-1 approval and proof of marriage get approved for the O-1 dependent. But they, again, as I said, they would not be work authorized. If they want to explore, if they want the ability to work, then, they can certainly apply for their own separate work visa too.
Two thoughts as well. We had a husband-wife duo get independent O-1s, like together as part of a team.
Yes.
So they each got their own O-1s. Also, if your spouse is your right-hand man or woman, or person, right? They are working with you in a role that's like essential to your role. Well, then it's possible for them to apply not as a spouse, but as an essential support personnel if you're coming in on an O-1B. This is where it's different to the O-1A. And again, you can see the nuances here and why, just the facts matter and the individuals, one case can be very different to another. But if you're, let's say I'm a major content creator, right? I don't think we're quite there yet with my maybe, TikTok but let's say your spouse is like helping you and is basically, your assistant,
and not just in like a very baseline way. It has to be a way that you can't just kind of easily train up somebody else.
They're there as your right-hand person.
Yeah.
Like, they can potentially go for the O supporting visa for you. And again, they're not applying as a spouse, they're applying as essential support personnel. So I think we can spend another few minutes just going through some of these questions. We're like running through all these.
Okay, so there was actually a few questions. I've been trying to keep track of the two places. But I've seen some questions come through about podcasting. So what if there's a big podcast with lots of followers and you've been invited on the podcast, and is it hard to establish or to use that in
I would say, what is your niche? What are we saying your expertise is in? We could potentially use podcast, I think, as media. Potentially.
For relevant evidence,
Yeah, and so we would want to look to see, again, what else are we including in that box, and see, does it make sense to include it? Also, if you are there on behalf of yourself or your company abroad, it's a great way to show that you've had a leading role with distinguished companies if you and your brand are featured on a really significant podcast as well. And I think, the one thing we didn't mention is that the evidence, right, those 6 boxes are ones that we can check, but we can also use comparable evidence if for some reason a box doesn't fit your particular industry or your occupation. So if there was a thing where we feel like, okay, this is not a situation where, commercial success applies. However, this is, and we'll provide evidence to show why it doesn't apply, like a letter, a testimonial or whatever, saying it's just not common in the industry. And then in lieu of that, instead of that, we have this evidence, and that is comparable and should be treated as such. There's some great language in the policy manual regarding that as well.
What about startups? Could we use a startup as a distinguished company that somebody had a lead role in?
Yeah, I think so. We work with startups all the time. How you show a startup is distinguished would be, have you raised venture capital funding? Have you raised angel investment? Or, have you been funded? If so, again, other people in the industry who literally invest as a live for, as a job, are thinking that your company is special enough to put their own money into your company. It's a good way to show distinguished. Also, startups get a lot of press sometimes. There's awards. I think startups live very well in the O-1, but we're normally thinking about the O-1A for startups. Not to say that we couldn't do the O-1B. I have done that as well. But, and also thinking of what is a startup. Normally it is a company that is either raising outside funding, or that's the expectation to give a significant return on it. So.
How does your education in your field, in your chosen field, help the application? Would it be beneficial to have a master's degree? It's not necessary, but there is a whole section that we put, the about me, kind of, about the beneficiary section. And it does help, it never hurts if there's kind of a background, maybe in something that's kind of related to the content creation. And we'll add in your degree certificates as well, and kind of reference all your profile, the background on your CV too.
I would say it never hurts, but it's also not a requisite. So if you're thinking, I'll add a master's and then I'll get my O, that's not a strategy that you likely need to incorporate into your plan. But big picture, immigration, these plans, I think, should holistically fit within your life. So if you are planning on doing a master's and we think it will be beneficial, great, we'll include it. But I think it's, to base your whole life around, something for immigration is just, maybe that's not the best way, right? And so this is why we start with, what are your goals? And can we design an immigration option around what you want versus just coming in and getting a job to work for a company because that's how your friend did it, and you're going to be on an employee O1 and won't have the flexibility you want.
And this question is directly related to that.
Oh.
For setting up your own company as petitioner, would this have to be set up in the U.S. and be a U.S. company, or could this be a U.K. company if an influencer is originally based in the U.K.? It would be a U.S. company.
Yeah,
we
for the
have,
petitioner.
And we have worked with a lot of our content creators have actually U.K. companies as well, because they're working there too, and so they might have ABC company in the U.K. and then they just work with a business lawyer in the U.S. to create ABC LLC in the U.S. And that's who will act as their petitioner.
Yeah. You can also structure potentially by using an agent for your US company, but there are, I think, a bit more limitations on that, and that would be an analysis that we would do, and we would say pros and cons, option A is this, pros and cons, option B is this, and then try to give you the guidance that I would give to my brother or my, cousin, right? Because that's kind of what people don't just want information, they want advice. Well, what would you do? Or what? And, I understand this because I also came to the US as an immigrant.
Do you work with traditional businesses? Yes, we do.
Yeah, our firm works with, we do all types of immigration.
This is just our little niche presentation for
Yes.
influencers. I love this one. Does age matter? Can they consider me too young for this visa?
This.
We love
a young beneficiary.
Yeah,
and the reason when I did the O1 presentation for our National Immigration Lawyers Association, we were in Orlando and we had all these hypos around Disney characters, and this was one that we called the Peter Pan. Okay, so what if you are young? Well, I mean, when here on this end, when we file the case, they do have your passport and they do see your age, but it's not as much of a concern, I think, as going into a visa stamping interview when you have an officer who's looking at you and seeing, oh my gosh, you look very young, how are you O1? I think you need to be prepared for those just for questions. But in any scenario, you should be prepared to know why you qualify for the O1, because even if the case was approved here by the Department of Homeland Security, you can't really prevent an overzealous immigration officer in an embassy or a consulate from trying to give you a hard time. So in any scenario, we would want to make sure that people are prepared for the interview. But there's no age limit. I think if you meet the O1, you meet the O1. And I've done these for people who were really young. So I think that, but again, it's just something to be aware of, but it is a great question. So thanks for asking that.
Maybe 2 more minutes.
Yeah, 2 more minutes.
Okay, they're still coming through.
We're gonna have to do another
or TikTok videos or something.
Yeah, they're so
What
good,
if
though.
the influence zone is particular to businesses in a specific region, like the Balkan states?
Okay, I would say what is your I need to know what
What's
your
the
expertise is. Are you a business expert giving advice about people?
And what will you be doing in the U.S.? Why do you need to be in the U.S. to, how can we frame it that you'll be continuing to work in that field?
And maybe it's advising companies about expanding to the Balkans, which I've actually met a group of companies that was over here in 2112 from that region, and so maybe that's it. But it's we just need to be thinking about how we're framing your expertise. And are you in content creation? Is this an O-1B? Are you more in the O-1A? But I think the good thing about the O, just in any O-1A, O-1B, is that there's no limit to, it can be industry agnostic, any industry, any field. It's more about how we are framing it with you, with the evidence in mind, and also with what your future, you're being mindful of your future work and what you want to do.
And I can finish with this one. If the applicant is switching from one visa, switching from a visa category within the United States to the O1, does that get processed faster than an applicant who's applying from outside the U.S.?
Yeah.
And so the application with USCIS would get processed the same. We can either do premium processing for slightly, well, they just extended a little bit those timelines, but it's a little bit faster processing for premium that's available. And then if we did a change of status, then your status would just automatically change to O1. Again, we'd kind of want to look at what status are you on right now, when does it expire. There's some specifics that we definitely want to go over.
If you're on ESTA, by the way, you can't do a change of status.
Yeah, so it has to be
visa, a particular visa type. But it's like, you don't want to come in on one visa and want to switch, so soon afterwards. How long have you been here? What is your status? When are you planning on traveling anyway? These are like the bullet points of questions that we would talk.
So it's like, yes, but.
Yeah, potentially.
Yeah. And then if you're outside the U.S., we'd still file with USCIS, so same options to expedite or file regular processing, but you would just have the additional step, unless you're a citizen of Canada and you don't necessarily need the visa stamp. But you'd have to apply for the O1 visa stamp in your passport at a U.S. embassy before you can come in and activate the O1.
Yeah.
But with that, there's more I know we didn't get to. We're going to keep track of them and find a way to get those answers to you. But thank you all so much for joining us. This was so fun.
It was so fun. I'm glad you all jumped on. I'm feeling the love through the comments.
And thank you for bearing with our tech issues.
Hopefully
it was worth sticking around.
Yeah, and we will have the recording. Thanks to Liz, who's been here on the chat as well. I think this will be, I feel like we could do a whole series of these, and we could break them down into like the O1 petitioner, the O1
really get
evidence.
Into it. Yeah,
even like each criteria could be its own thing. So yeah, hopefully you all have a great day. Wish me giving Anna safe travels back to California.
Yes, about to run out for my flight right now.
Yeah, so we gotta run. Okay, thanks everybody.
Thank you.
Bye.